Hello friends, very warm welcome to my Business Laws channel. In the last video friends, I had covered for chapter number 4, I had started which was competency of the parties to contract. And till now I have covered law relating to minus agreements. So there are three persons incompetent to contract. One is the minor person, second is a person of unsound mind, and the third is disqualified persons. So today in this video class, I'm going to cover persons of unsound mind and then I will cover disqualified persons. Now the question arises, what is the meaning of sound mind and unsound mind? How can we say the person has sound mind or the person doesn't have sound mind? A sound mind person has been defined under section 12, which provides he is capable of understanding it or of forming a rational judgment as to its effects upon his interest. So friends, we can say there are two tests which we have to apply. First is capability of the party to understand the contract. And second is ability to form the rational judgment as to its effects upon his interest. So friends, we can say we have to pose two questions. First question is, can he understand the contract? Does he have the capacity to understand the contract? And then after understanding the contract, can he form the rational judgment how the contract will affect his interest? If the question for these two, answer for these two questions is affirmative, then we will say the person bears sound mind. Otherwise, we will say that he does not bear sound mind. So friends, I have explained the definition of the unsound mind, which is provided under section 12 of the ICA 1872. And section 12 of ICA 1872 further provides 2 points. First is a person who is usually of sound mind, but occasionally of unsound mind may make a contract when he is of sound mind. So whenever he has sound mind, he should contract. A patient in a lunatic position who is at intervals of sound mind may contract during those intervals. Whenever he has sound mind, it's very simple. Whenever he has sound mind, then only he should contract. A person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. So mainly, the point which should be borne in mind is that person should not contract whenever he has unsound mind. A sane man who is delirious from fever and who is so drunk that he cannot understand the terms of the contract or form rational judgment how the contract will affect his interest. So he cannot contract so far as he is under their influence at such delirium or drunkenness. Now the question arises, what are the various forms of unsound mind? So friends, unsound mind may arise from, unsoundness of the mind may arise from, first point is idiocy. This idiocy is God-given. It is permanent with no intervals of saneness. Here friends, incapacity is permanent. The mental powers of an idiot are completely absent because of lack of development of the brain. So the moment this person takes birth on the earth, his mental faculties are not fully developed. So we can say here incapacity is permanent. Now there is a leading case law regarding this, which is before you friends, Inder Singh Parmeshwar Dhani Singh. So Inder Singh versus Parmeshwar Dhani Singh. Now the facts of this case are a property worth rupees 25,000 was agreed to be sold by a person for rupees 7,000 only. So property was worth rupees 25,000, but it was being sold for 7,000 only. So his mother proved that he was congenial idiot incapable of understanding the transaction, so the sale was held to be void. So the second reason is, friends, that second reason is lunacy or insanity. It is a disease of the brain. A lunatic loses the use of his reason due to some mental strain or disease. Of course, he may have lucid intervals. Now, what is the meaning of lucid intervals? Lucid intervals is a period in which he is in his senses. So he should always contract during his lucid periods because he can understand during this period. He is in his senses. So friends, there is a difference between idiocy and lunacy. In case of idiocy, incapacity is permanent. But in case of lunacy, it is not permanent, it is temporary. If he is not in his senses, he cannot contract. But the moment he comes to in his senses, then he again becomes competent to contract. So during lucid intervals, such person can always contract. See, for example, when the person took birth on the earth, he was perfectly well. But after some time, unfortunately, he was going somewhere and he met with an accident. So here, he had head injuries. So he became unconscious. So during that period, of course, he cannot contract. So when a treatment is over, he becomes normal, then in that case, he can contract. So I hope you must have understood the difference between idiocy and lunacy. Now, third reason is drunkenness, or it is also known as intoxication. It produces temporary incapacity till the drunkard is under the effect of intoxication, provided it is so excessive as to suspend the reason for a time and create importance of mind. So any person who is under the influence of drunkenness or intoxication, such person also, so far as he is under the influence, he cannot contract. But once the influence is over, he again becomes competent to contract. Now next is hypnotism. It also produces temporary incapacity till the person is under the impact of artificially induced sleep. So here, friends, that hypnotized person is under the influence of somebody else. He cannot understand, he cannot take decision because he cannot understand what is good for him, what is bad for him, how the contract will affect his interest because he is not in his senses. So friends, hypnotism is another form of unsound mind. Now next is mental decay. This is on account of old age. Now in old, a person is not mentally active always. During old age, the person becomes inactive. So sometimes, he cannot understand the contract or he cannot form the rational judgment. So when the person will become inactive, we cannot state particular age. It differs from person to person depending upon his lifestyle. So friends, now the question arises, who will prove that person has sound mind or the person doesn't have the sound mind? So the burden of proof always lies on the party who sets up such disability. The person who says the other person is not competent to contract because he doesn't bear sound mind, so he has to prove that the person is disabled or the person is not competent to contract. But if the unsoundness of the mind is once established, the burden of providing a lucid interval is on him. So friends, here the unsound mind person, if he is having the lucid intervals, then he has to prove that he is having the lucid intervals, so he is competent to contract. Now, what is the effect or impact of agreements made by persons of unsound mind? Now here, an agreement entered into by a person of unsound mind is treated on the same footing as that of minors. So friends, the meaning is that all the agreements which are, all provisions which are applicable in case of minor, the same provisions are applicable in case of person of unsound mind also. Or we can say in other words, an agreement by a person of unsound mind is absolutely void and inoperative as against him, but he can derive the benefits under it. So there's a case law regarding this, which is Jugal Kishore versus Chedar. And now this is all about the person of sound mind and unsound mind. And now, friends, I'll take up the third category of a person incompetent to contract, which is disqualified persons. Now, disqualified persons, this category may arise by the status of the persons, national status or political status or corporate status, etc. So the following category of persons, they are included in the term disqualified persons. So now I'll take up all the points one by one. First is alien enemy. The general rule of law is, friends, alien friend can contract, but alien enemy cannot. Now the question arises, what is the meaning of the term alien friend, alien person? Any person who is not the citizen of India is known as, was the citizen of India was not the citizen of India is known as alien. He may be alien friend or alien enemy. If the two countries are having good terms with each other, then he will be known as alien friend. Now, if the countries are not having good terms with each other, then he will be known as alien enemy. So the contracts may be suspended during the war and may be revived after the war is over, provided they are not time barred. X, an Indian citizen, carries on a business in Pakistan. He enters into a contract with Y, who carries on business in India. Immediately after the formation of the contract, a war broke out between India and Pakistan. In this case, X becomes an alien enemy. Though he is Indian, and contract between X and Y will be suspended for the duration of the war and revived after the war is over. So friends, I would like to repeat this point that alien friend can contract, but alien enemy cannot. Now, second point is foreign sovereigns and ambassadors. They have special privileges and generally cannot be sued unless they are of their own. They have to submit to the jurisdiction of our law courts. So, and if they do something wrong, then in that case, without seeking the permission of the central government, we cannot take action against them. That is why they have been kept under the category of disqualified persons. Convict person. A convict cannot enter into a contract while he is undergoing imprisonment. Convict is a person who has done something wrong and he has been put in the jail. Okay, so during the period of imprisonment, he is not competent to contract. When his period of sentence is over, then he becomes competent to contract. Insolvent person. Any person who is unable to pay his debts. His assets are lesser than his liabilities. Or we can say his liabilities are more than his assets. Such person is insolvent person. So in such cases, officer is appointed by the court and all his assets, liabilities, they are transferred to the person and that officer is known as official receiver or official assignee. So he can enter into the contract relating to his property and can sue and be sued on his behalf. So friends, here insolvent person has also been placed under the category of disqualified persons. Then joint stock company and corporations incorporated under a special act. So many incorporations may be there. RBI may be there, LIC, IDBI may be there. Now there was a Companies Act 1956 which has been replaced by Companies Act 2013. Now it cannot enter into the contract outside the powers conferred upon its memorandum of association or by the provisions of the special acts. So friends, all ultra vires acts, even company is not competent to contract. Ultra vires word is made up of two terms. One is ultra, second is vires. Ultra means beyond and vires means powers. any act which is beyond the powers of the company, even for that, the company is not competent to contract. And company is the artificial person, and company cannot enter into the contract of strictly personal nature, that learning a dance, going for marriage, or learning any skill. So these are the contracts which cannot be entered into by the company, as the company is the artificial person. Then married women, according to section 4 of the Married Women Act 1874, a married woman is competent to make a contract with respect to her personal property, including alimony. Now I would like to explain the term alimony. Alimony is the amount which is ordered by the court in case of divorce, that husband has to pay this much money to the spouse because there is a divorce between the two. So this money also belongs to the wife. So wife has full control, authority over this money. So she can enter into the contract regarding those properties which are in her own name. But any property which is not in the name of the wife, that is in the name of her husband, for that she is not competent to contract. And after that, the last point is professionals. In England, barristers are not allowed to enter into any contract relating to their profession, pursue their clients for the recovery of their fees. But in India, courts have recognized the right of barristers enrolled as an advocate of an Indian High Court to sue his client for his fees. According to Bar Council Act 1927, an advocate of the High Court can enter into a contract with his client and can also bring a suit against him for his fees. So friends, I hope so what I have covered today, I have covered in my video class today two categories. First was person of unsound mind, and the second was disqualified persons. So thank you all. It is all from my side for chapter number 4 and for this video lecture 2. I hope you must have understood the content. If you find any problem, you can always write in the comment section. So do like my videos, do subscribe to my channel, do press on the bell icon to get more notifications of my subsequent videos. So it is all about today. Stay blessed always. Okay, bye-bye.